All right, is everybody ready?
Yes, Shona.
Okay, so there's a couple other rules. So we also know, if you've been in front of me, because I know several of you have, that what we also like to do is we like to put it on the transcript that the court reporter gets paid. Typically, I say 5 days, but it seems like Madam Court Reporter here has a link that she sends out that she gets paid by the end of the business day or the end of the day period. So, and there's lawyers on here, so we're going to put it on the record. Both sides are sharing and takedown. Mr. Tannen?
Yes, you're sharing takedown.
Ms. Rubel?
Yes, ma'am. We are sharing a takedown.
Okay, so she does send out a link. So if she does not get paid by the end of the business day, and if for some reason somebody's too tired and they go home absolutely by the next morning, then we will appear in front of me and we'll discuss why she hasn't been paid. And the side that doesn't pay will purge at Rice Street. Okay, so if you have witnesses in the room with you, you both can't have your computers on at the same time. And let me tell you, if Ms. Sanders has to interrupt more than once because people are talking over one another, or people have their computer speakers on at the same time, and she has to keep doing that, and she gets angry, then I'm going to get angry. Okay? And Mr. Tannen, I know you and I both wear hearing aids because we can't, and we're very proud of them. So crank them up, listen closely, because this is good.
Sorry.
Yeah, I have mine cranked up, and I'm sitting my volume on my and we're very proud of it. It's not a shame, you know. If my dad would just wear his, so I have my volume turned up on my headphones so I can hear everything, and also I speak with a very thick Southern accent. So if somebody can't understand me, I'm really working on it. But you know, just try to slow down if you speak with an accent like me, you know, and make it easy for the court reporter to take down if you don't mind. Now, since this is my first time hearing this, I'm not sure who I need to put in the waiting room as a witness. So I think the parties are Mr. John and Miss John, right?
Miss Phillips.
Miss Phillips. Where's Miss Phillips? Oh,
Yes.
Sheena Phillips right there, right?
Yeah, Sheena Phillips. Yeah.
All right, so everybody else on here will go into the waiting room except for Ms. Williams and Mr. Tannen, Ms. Rubel. Who else?
O. Volkert. O. Volkert is a paralegal in my office.
Okay, all right. So we'll put everybody in a waiting room. If once I put somebody obviously in a waiting room that doesn't belong in there, we can bring them back in. If anybody gets kicked out, just please sign back in. Let's see. And we don't have the same thing going that that I think they had last time because we're on a different format. And if for some reason I do pronounce something wrong, it's definitely my accent. It has nothing to do with I'll do my best. No offense to anybody. All right, is this everybody besides my podium in the waiting room there that's on? And I apologize, nobody's in there, but I'm having to practice with our monitors in the courtroom. There's nobody in there, but I have to practice to make sure they're still working.
Yeah, I think that we've got everybody. We got the parties. And then the two paralegals. I don't know if Tannen has anybody else from his office, but it does look when I scroll that everybody's in.
Mr. Carlson is here and nothing signing in. She's my associate.
Anybody else, Mr. Tannen, that I need to let in?
No, you know, I do see, and I don't know what this means, SCAHG gallery.
Oh, no, those are so those are our monitors in my courtroom.
Oh, okay.
Yeah, I'm just we just are really learning how to set them up. So I'm just making sure that they're working because they tend to be signing off. So just kind of practicing with them to making sure that they're working. Nobody's in the courtroom, and there's a podium, a waiting room, which is outside, prosecutor gallery, and one just making sure they're working when we do stuff remotely in here. And if we see somebody in the courtroom, obviously they're probably emptying the garbage. All right, we'll start. We'll both parties raise your right hand. All right. Do you swear or affirm testimony you're about to give in this hearing is the truth, whole truth, nothing but the truth? Sir? Yeah, unmute yourself, please.
Yes, Your Honor.
All right, ma'am.
Yes.
All right, this is a, what is that say off the pretrial? There. So this is John Tish, is that correct, sir?
That's
John and let's see, I have Shinamal Philip, is that right? Or Shinamal Philip? That's civil action number 2020 CV 335858. This is Family Division 2 of Judge Alex Manning filling in for Judge Craig Schwall. All right, so we're gonna go to openings. So Mr. John's lawyer is Rubel, I believe, right?
Yes, yes, ma'am.
Mr. Tannen is Mr. Phillips' attorney. Okay, and remind,
We started the case before Judge Schwall. Two witnesses were sworn and examined. So I'm just curious procedurally, are we starting all over again? What are we doing?
yep, gonna just start all over again, but we're to tell you what we're gonna do. We're not gonna talk over each other once again. And everybody's gonna listen real closely, turn up their mics. If anything needs to be spelled, we're gonna spell it for Miss Sanders. And we're not gonna have a whole bunch of arguing back and forth. Then we're gonna go through it because from what I understand, there was back and forth about somebody not hearing and arguing back and forth and trouble with people getting put out in breakout rooms because of the Zoom type they were using, because the Zoom type, I forget what it is, but it doesn't agree too well with breakout rooms and it sends people different places. So we're using the Zoom thing that I use. So this is what we're going to do. All right. So we are starting all over again.
If I may, Your Honor, just to try to address some pretrial issues. There was an amended consolidated pretrial order entered in the case. I believe that we've uploaded that to Your Honor that identified witnesses and exhibits. Now that was all entered and the deadline was on, well, it was filed on April 15th prior to the 2 days we attempted to appear in front of Judge Schwall.
Right. I do have that.
And we did, prior to trial, we provided a notice, and I say Mr. John provided a notice of intent to tender business records. There were some cell phone records and some other records provided to opposing counsel. Judge Schwall during a pretrial conference had admitted those records as authenticated business records. Since notice was provided, I didn't know if you wanted us to re-argue those issues or.
If he's already admitted them, that's fine. We could leave. Oh,
Okay.
And
then.
And then the order was granted on the motion to quash, and the judge admitted them anyway.
Okay, well, I won't second guess Judge Schwall. If he admitted them, he admitted them. If he argued them, if he argued that and he granted them, he admitted them. I'm not gonna, overrule anything he said. So if they're admitted, they're admitted.
Okay, and then the additional issue is that it is my understanding opposing counsel intends to try to introduce testimony from 2 additional witnesses that were not included on the consolidated pretrial order, and they were disclosed after the second attempt to have this trial, or at least continue the trial. So I would object to the additional witnesses, any testimony by the additional witnesses or any documents they intend to discuss, because that was way after the amended pretrial order. There was no discovery on it. There was nothing that was disclosed in discovery. And so I would object. I believe one of them they're attempting to admit as an expert, and I completely object to that. This line, any evidence. Now, specifically, I think it's one of their exhibits that related to it is an quote investigative report. I think it's exhibit 38. And then they included their email regarding additional witnesses as exhibit 37. So that would be my contention. I would just ask the court, it's essentially a motion in limine related to those 2 witnesses and any evidence that is intended for them. It would be their exhibit, I'm presuming 37, 38. Let me see what 39 is. That's a court order I don't object to. And then email regarding discovery. So it looks like it's just going to be related to exhibits 37 and 30, or exhibits 37 and 38 from opposing counsel. So defendants And if I need to screen share the amended consolidated pretrial order, Your Honor, I can. Just let me know, and I'll let Mr. Tannen if he has a response.
I have a copy of that. Go ahead, Mr. Tannen, you want to respond?
Yeah, Judge, the first witness, the expert, was made necessary by the fact that despite the motion to quash being granted in our favor regarding AT&T, who's Judge Schwal, we had no anticipation that we would need to respond or would argue with respect to that. However, at the start of the trial, Judge Schwal, despite his order, admitted the records. So we were, between a rock and a hard place on that. So we were necessarily needed to call this expert, who is not going to be called when needed otherwise. Moreover, Judge, with respect to the second witness, the reason that we are calling him is because he was approached subsequent to the entry of the pretrial order by Mr. John, I believe, and certain people on his behalf to attempt to influence Miss George, his client. This man is an attorney in India, testimony, and to get her not to testify. So there's nothing we could disclose earlier about that. Further, when you go to the case of Lee versus Smith, decided February 10, 2020, it's in the Supreme Court of Georgia, S18G 1549, the Supreme Court of our state held no harsher sanctions are necessary to indicate the court's authority, and determining whether to exclude a witness who is not timely identified, the explanation for the failure to the trial court should consider the explanation, the importance of the testimony, and the prejudice to the opposing party, and whether a less harsh remedy, such as continuation of the trial, should be allowed. Thus, based on all of what I stated to you, in this case, I believe that the information is vital, that the Supreme Court has ruled that it should be admitted, and we would respectfully request that these witnesses be allowed to testify and the evidence admitted.
Go ahead, Ms. Rubel.
If I may respond, Your Honor, related to the order on a motion to quash, there were some non-party subpoenas sent to AT&T by Mr. John, by our office, to obtain the cell phone records of Ms. Sheena Mulfilla. Those records were obtained prior to an order on the motion to quash. So Judge Schwal entered an order quashing the subpoena after the records had already been obtained. And pursuant to the Civil Practice Act, you have to actually obtain an order prior to the production to block it. Now, there was never a ruling on the admissibility of the evidence, never, until Judge Schwal admitted those records during the pretrial. I will note in our amended consolidated pretrial order, we included as evidence communications between Ms. Sheena and other individuals. So the documents themselves were identified in our amended consolidated pretrial order. So the specific claim that they had no idea or they needed these rebuttal witnesses or rebuttal evidence is contradictory to what we disclosed in our consolidated pretrial order, in addition to the non-party intent that we sent, the notice of intent to tender business records, which were AT&T's records. So to say, oh, well, we needed it because during the trial, this information came out. No, that information was shared in discovery, which provided as a notice of intent prior to any trial starting. The evidence was listed in our consolidated pretrial order. And to come up with, it's my understanding, one alleged expert witness, which is just to claim that now there's a new expert that I can't depose, that I have no information on, if not, and then additionally, an attorney in India. Now we're involving an attorney in India that is not the witness. Any witnesses listed. I'm not sure what this person would have to testify or the relevance of that, but I believe that it's inappropriate, and that's what we would consider trial by ambush when this has already begun. There's a reason why we enter consolidated pretrial orders. It's so that every attorney has a fair advantage to represent their client's interests in full disclosure, and that's not what's happening here.
Well, Judge, in response, if I might say, I would notice that the notice to introduce the evidence was filed by opposing counsel on 4/20, the day of the trial, not weeks before. So we didn't have really advanced notice of it. We had notice as of the day of the trial. As to the attorney, we're not seeking to have him testify as an expert witness. We're having him testify as a fact witness, that he was influenced or attempted to be influenced to speak to Ms. George, one of our other witnesses, to have her reconsider her testimony. That all said, Judge, if counsel wants the chance to depose our opposing counsel, we've got no objection to a continuance, and based on Lee versus Smith, given the importance of these, we're ready to continue again.
Okay, well, this isn't going to be continued, so no on the expert witness. Absolutely no. We're not continuing this for a deposition. No. And what else does this attorney know from India? Is this going to be redundant?
No.
Well,
It's going to be firsthand. It's going to be the fact that he was the opposing party and certain of his family members called him directly to have him influence his client.
So, Mr. Tannen, I'm not sure if it's just me or it's everybody else can hear this. You have some sort of noise when you speak. It's like shh going on when you speak. Is there something close to your microphone or something else? Because when you speak, it's kind of like white noise.
The only thing I'm doing, Judge, is I'm having my client who just had her screen up move to another room to see if that helps.
No. Do you have a phone or some other electronic equipment sitting near it?
No, ma'am, I don't.
Do you not hear it every time that you speak or say something? You don't hear the extra noise?
Well, I don't hear a lot, but you know.
Well, I mean, yeah, I've got mine on, but mine, I don't think mine's making extra noise.
Okay. Is that better, Jill?
No, not really.
There are landscapers outside. Let me try and turn my volume down a little bit, see if that helps.
All right, how about now, Mr. Tannen?
How's that working, Judge?
Oh my, 1,000 times better. Perfect.
Okay, awesome.
All right.
Much better.
Sometimes it does work, turning it off and turning back on.
The IT crowd, yes.
Okay, Your Honor, if you're ready, I will proceed.
Yes. And so as far as the expert, yes, they're out.
Oh.
And this other witness, the attorney, I mean, when did you make her, Ms. Rubel, aware of the other witness, the lawyer from India? Like,
You know what, Judge, now I've got to get you a little louder, so hang on for a second. I'm sorry, ma'am.
no, that's okay.
Can you repeat that, Judge, please?
When did you make the other side aware of the, oh, it was just after this amended pretrial that you made her aware of the,
Right, as soon as we knew about this and it came to our awareness.
well, I mean, yeah, I
The
don't think
notice I received was April 30th, actually, not after, just after. It was after the second day of trial, the second trial date.
oh. Yeah, no, I don't think I'm going to let this other one. I mean, because I see there's a whole bunch of witnesses that you have here, Mr. Tannen. I don't think if you can't make up your case with all these other witnesses.
Judge, it was before the second trial date, according to my associate.
Well, I mean, but you guys were ready on the first trial date and didn't go forward, and then the second trial date, so you should be ready to go forward on what you have now.
That's fine, Judge, except, you know, I can't make evidence appear, and when it does, I got to do what I got to do.
But you had evidence before.
I do have evidence before, but this is new evidence.
Well, I mean, you know, you had it before. I don't know that it's new evidence if you have other fact witnesses. So yeah, I'm not going to let it in now. You can't. This isn't Law and Order. You know that you get it the next day and you walk in. You say, "I just found this." I mean, you had it before, Mr. Tannen. Your client obviously knew of the evidence, and your client should have told you before. Hey, your client just didn't discover this other fact witness. Your client should have known about this fact witness. Actually, your client should have known about this fact witness at the beginning of the case. So, all right, let's get started. Go ahead with openings.
So let me share this because I'm a visual person.
Still with me.
Okay, what I have done for the court, because there are two pending cases, so between the parties kind of against each other. So what I tried to do was identify all the issues that are before the court and just kind of bullet point who made what claim and what the issue was, just so you can see, one, why this is going to take a day of trial, and two, just to direct kind of the issues that were alleged in the pleadings. So if you can see that there. My client, Mr. John, has filed a modification of child support for the party's two children. The modification of child support is requesting the removal of childcare expenses for the children. The children are teenagers. I believe they're 16 or older at this point. And there was a child support order, the child support addendum from the party's divorce in 2016 that included childcare expenses for these two children in the worksheet. So it's been auto deducted from my client's income through the income deduction order. We wanted to update the child support calculations based on the party's income. Mother's claim, and those are the two fathers' claims. Mother's claim is that there's been an increase in the children's expenses, and so she wants those issues presented to the court, and that father has failed to exercise parenting time such that she should have an increase in support. And I will say on this specific issue, the modification of child support was addressed by Judge Swall on a temporary basis. We had a temporary hearing and there's a temporary order entered. At that time, I believe it was in October of 2020, Judge Swall did remove the child care expenses from the child support worksheet. He did not update the party's income, but at least said, look, I know that this doesn't exist anymore. And so he entered an order on that. Now, we also, what is presented before the court today is essentially a declaratory judgment action of when did the alimony that father pays to mother end. One of the core issues in the case is that pursuant to the party's final judgment decree, there was a final hearing in front of Judge Barwick. Judge Barwick entered an order, the final decree, and says that alimony terminates upon wife's entry into a meretricious relationship. It doesn't say this is modifiable. If she does, it says that's when it stops. So the issue to the court is, when did mom enter this meretricious relationship or remarry pursuant to the final judgment decree of divorce? Opposing counsel, I believe, has filed a counterclaim or a response in one of their pleadings claiming this is a modification of alimony and it's improper because the alimony period has already expired. And to be clear, this is not a modification of alimony. This is I need to, just like you would when you had child support, if the child support order says it stops when the child reaches the age of majority, that's the date it stops. You don't have to modify it. That's the same thing that had a terminating date in the final judgment decree. Now, the reason why my client couldn't stop paying is because there was an income deduction order that was withdrawing the money. And so this case was pending before Judge Swall. And what happened at the temporary hearing when we brought up the child support issue, the judge said, look, I'm modifying the child support and I'm also going to eliminate the income deduction order because at that time, my client was about to make the final payment for alimony. It was already going to get taken out of his paycheck. And that point, it was the judge just said, well, look, I'm going to change the IDO at this point because no matter who's right, the money doesn't need to be paid anymore. And we've been pushing for a temporary hearing during the case, but couldn't get that temporary hearing until months after, my client had to, couldn't change the income deduction order. So that's kind of the background on this. And the evidence is going to show, and one of the exhibits that's been tendered and admitted by the court were WhatsApp messages from Father Matthew, and his last name is very difficult to say, but I will try to get him to do that. And he is, I believe, a priest at the Catholic Church, one of the churches. And so there are messages between him and another witness where he says that he performed the wedding ceremony of Miss Phillip and another individual, Sabu. And that was relayed, and apparently that happened sometime in June, I believe, of 2019. I'll get to the messages. But so that was, it was F43, Father's messages that were tendered. Now, Father Matthew is available. He's a witness again. Binu Monsi, the person he communicated with, is a witness. But we believe the evidence shows that he communicated, he performed the marriage ceremony, but specifically said, don't tell Mr. John because then he'll have to stop paying alimony. And one of the struggles that we've had is that the alleged person that Miss Phillip was in a relationship with, we haven't been able to locate him. And so I believe mother's position is he doesn't exist. And our position is, why are there all these communications from people saying this ceremony happened and this person exists and this information, and it's, this is way too specific for this to be just fake. Now, the modification of visitation. Mother has filed a modification of visitation saying that fathers refused to exercise parenting time. We will present evidence that shows that the minor children have been alienated by the mother. We have recordings of the children, and they have been subpoenaed as witnesses to just give the court an understanding of where they're coming from, and hit where he's coming from. He's trying to work with them, but teenagers are tough when they've been alienated. It's just been difficult. Mother claims that father has disparaged and insulted her to the children. This is one of her contempt claims, so that's why I put it in there, not as just a complaint. Mother's position is that the minor children are old enough to limit their parenting time with father, and it should be their choice. And our client doesn't agree with that. So that's mother's petition for a modification of the parenting time. He has limited parenting time. It's like every other weekend. It's not much, and he hasn't been able to exercise it because they refuse to come to his house. Contempt issues. So this is a summary of the contempt issues. Mother initially started this action with a contempt. Mr. Tannen filed a contempt of alimony and child support, claiming money owed by father. That issue was resolved. My client, prior to hiring us, the evidence is going to show, went into Mr. Tannen's office, worked with Mr. Tannen on what the requests were prior to even having a court hearing, did everything he was asked, was told that this would resolve all the issues to dismiss the complaint, paid attorney's fees to Mr. Tannen. We have that canceled check as well, for consideration, and then they proceeded with continuing their claim. We think that that's completely bad faith. That claim is still pending at this point is, I can't understand, even with an amount of attorney's fees that was paid. Now, we have a contempt claim pending against mom. It's for failure to return 8 gold finger rings pursuant to the final judgment decree. Judge Barwick, at the final hearing, testimony was presented as to personal property that my client wanted returned. This family is Indian, and there were some gold finger rings that were from family heirlooms that were in the possession of, based on Judge Barwick's ruling, were in mother's possession, Miss Phillip's possession. She ordered that those rings be returned. The rings were not returned. Instead, what happened is the court will find that there was evidence presented in mother's response to our contempt. Mother says, oh, it just says rings, and she just mailed rings to father. Now, the rings are like women's cheap knockoff rings that are, and they don't fit on my client's fingers. And so we'll present evidence of the marriage ceremony that shows the gold finger rings on my client's fingers, what they look like, and then some other evidence as to the alleged value. Now, it's also my understanding mother has submitted evidence during the pendency of the case saying that the rings were never in her possession. They are in my client's mom's possession in India, Miss Mary George. Alone, those two positions can both not be true. You can't swear under oath and say that I returned the rings and then swear under oath and say, no, they've never been in my possession. So we will have testimony related to whether or not they were in his mother's possession and my client's personal knowledge of that and other personal knowledge of that. But we would like the value of the rings. Now, mother has filed a contempt against father for disparaging, claiming that he's disparaging mother to the children. He doesn't have any contact with them, but apparently this is one of their claims. That father is harassing mother in the following ways: repeatedly insulting, disparaging, and making untrue statements, creating fictitious entities, alleging she's in a meretricious relationship, and accusing her of financially supporting religious institutions, and accusing her of witchcraft. Now, these, I believe most, if not all of these allegations were my client's responses to interrogatories in the action. And so that's where those statements would have come from, unless there's some other evidence I'm not aware of. Now, oh, I'm sorry, it continues. Alleging that Miss Phillip is mentally harassing Miss Mary George, Mr. John's mother, attempting to have Miss Phillip arrested for conspiring to murder him, filing a contempt action against Philip to recover rings of the fair market value, which he knows are in his mother's possession. So this is a new contempt. Mother filed this new contempt in January of this year. After, in her response to the original contempt, she said, oh no, I returned him and did everything I was supposed to do. So she's asking the court to hold my client in contempt for harassing her because he's got a claim and now saying there's with somebody else. And that father has failed to pay $2,978.25 for a portion of orthodontia expenses. The evidence is going to show that this alleged orthodontia expense, the invoice was never sent to my client. However, in an abundance of caution and my client not being able to still obtain the invoice, my client paid the amount to Ms. Phillip and is asking, in the event that that information isn't proffered to the court, that he be reimbursed that amount. We're asking for attorney's fees in this matter pursuant to the contempt statute, modification of custody statute, and the child support statute, and give you the specific citations. Contempt is 1962. The modification of custody is the custody statute 1993G, and child support is the child support statute for the court. So that was lengthy. I recognize that, but that's why I summarized all of these issues that are in the pleadings for the court. We're going to upload this issue summary to the court as well. And we have a proposal to the court that we're going to share as far as what should happen, as far as income findings. Generally, we believe that the evidence is going to show that Ms. Phillip remarried another individual in secret, hid it from Mr. John to continue to receive alimony, that the testimony, unfortunately, from my client's mother, the evidence is going to show that she's had mental health issues for over probably about 10 years since her husband passed away and even prior, and that she's just not in the right mind to even know what's up and down at this point. And unfortunately, it's created a complete fracture in my client's family. And we believe that my client can prove that the 8 finger rings were not returned to him, what they were. We have evidence that'll show the alleged value of each ring that was comparable for payment of that, and then attorney's fees, which has been substantial in this case. We'll have proffer our attorney's fees. Unfortunately, with this many enumerated issues and companion cases, to make sure that we gather evidence to defend against, I can't lost count, these different, that's 9 harassment or 9 different contempts just alone by Ms. Phillip against my client that we're having to defend against.
Mr. Tannen? Mr. Tannen, you're on mute. I thought for a second he was talking to his client, but there you go.
Sorry about that, Judge.
I wasn't sure if you were talking to your client first or continuing, so go ahead.
Okay. So I'm just going to respond in the order provided by Ms. Rubel to the best that I can. Basically, our position is that the claims of marriage or meretricious relationship and the rings are all really based on vindictiveness, harassment, and retribution sought by the opposing party. The claim for contempt was filed by my client in November of 2019. The modification action was filed in May of 2020. This is the first time that Mr. John filed any claims or any claims regarding the rings or the marriage or anything else that was raised by Ms. Rubel. Let's go through quickly the modification of child support. The modification of child support is really the crux of the issue here. I will note to the court that on father's income, he is underreporting his income on an average of about $30,000 a year. And we will be able to prove that to the court by documents provided by Mr. John's employer as well as tax returns provided by Mr. John. I will note that the exercise of parenting time by Mr. John was never raised prior to the modification. And in fact, for a period of 2 years, from I believe 2016 to 2018, Mr. John exercised no parenting time. We also have the affidavits of the young ladies, the children, and their willingness, if not their desire to testify, as to their relationships with their mother and their father, and who was alienating whom. Now, fortunately, these are not very young children. I would never want to do that, but the case has transpired in such a way that I don't know a way around it. And we will follow the court's instruction as to the best way to interview these children so it's the least harmful to them as possible, while recognizing, geez Louise, this is inherently difficult. The kids are going to testify that their mother has never alienated them from their father, that the kids' mother has always been respectful of the father, but that the father has always tried to alienate the mother, plant lies about her, etc. But you can speak to the kids about that and you'll find that out. With respect to the extracurriculars, Ms. Rubel did raise a point. Father had failed in the earlier action, and the basis for our contempt was to reimburse certain amounts for the extracurriculars. As a result of that acknowledged and agreed upon by the opposing party failure, we're seeking to build in the extracurriculars and other appropriate items, special educational, extracurricular, etc., into the amount sought in the worksheet. So in sum, we're seeking an appropriate amount for child support based on the true income of father, the parenting time deviation, given what the girls are going to say, and that in lieu of a reimbursement process for special education and extracurriculars, that those amounts be built into the worksheet because of father's past failures to provide reimbursement timely or fully or voluntarily. Let's move now on to the claim for alimony, and that it is being terminated by the fact that Ms. Phillip has entered, theoretically or allegedly, into a marriage or meretricious relationship. Well, Father Matthew, the person who Ms. Rubel's case relies heavily upon, is going to testify that he never married them. The parties, not the parties, Ms. Phillip and this allegedly existing third party, that he does not know where these texts or emails allegedly from him came, that he did not send them, and there is no expert proof that can be provided to link Father Matthew with the phone number alleged. Moreover, let's take the word, we will establish as well that the only thing that has been alleged by the opposing party is a secret marriage in Georgia. There is no church records being provided. There are no, I think Catholics have to publish these things called banns. There's no banns. There's no church records. There's no marriage certificate file. And there's no marriage license. So even if the worst is assumed, there's no valid marriage in Georgia. So because Georgia, as you know, does not recognize common law marriage. Consequently, absent that stuff, no marriage. Next, they're talking about a meretricious relationship. Well, the evidence, or a cohabitation in a meretricious relationship. And Judge, you know the statute as well as I do. That doesn't mean you're hooking up for a week of nookie or you're taking a trip together. It means you're living together in an open relationship, acknowledging your situation, etc. No evidence is provided as to that. None, zero, nada. So even if the other side is going to allege that they took a trip together to Houston, which we deny, there's no evidence that this man resided, lived at the house in a manner which would constitute cohabitation in a meretricious relationship. As a result, those two things fail. Alimony is the termination of alimony prior to the expiration date falls out. Now, and any amounts which may have been repaid by Ms. Phillip prior to the actual termination date should be again reimbursed to her. That said, let's then go on to, excuse me, I'm sorry, the rings. Oh, the rings. What Ms. Rubel fails to mention is that the rings were returned by Ms. Phillip 4.5 years ago. And Mr. John's attorney at the time signed a receipt for them. Mr. John made no claim for the rings prior to the filing in May of 2020, or April rather, of his modification action. So he sat with the rings for 4.5 years, and only when he's filing a modification does he realize, geez Louise, these are fake. Interestingly as well, Ms. Rubel, I don't believe intentionally, but slightly misquotes the settlement agreement. It says that Ms. Phillip will return 8 rings in her possession. It doesn't say gold rings. This is on paragraph 10, Judge, of the final judgment and degree of divorce. Ms. Phillip will testify that the only rings she had were the rings that she returned. And then we followed up and found out that Ms. George, who the other side is falsely claiming as mentally impaired, and we will establish that, Ms. George said, hey, no, I have these gold rings, and I kept these rings and passed them on. So the concept that somebody's waited 4.5 years to file a claim for specious, is inherently specious, and the evidence will prove that. What am I missing? Oh, the modification and visitation, where you'll, again, the evidence will show that the girls, by the girl's own testimony, the father really never claimed the interest in them. And then let's go on as well, by the way, to the child support. Ms. Rubel made it back to it. I apologize, I'm just revisiting it. Ms. Rubel made a claim that the judge modified child support downward. And indeed, he modified it downward in part to take out those extracurricular activities which were included in the child support worksheet. I'm sorry, childcare. But he also reduced it based on the income reported by Mr. John, and also his allegations regarding health insurance costs. We will establish to the court and prove to the court through documents provided by his employer and documents provided by Mr. John himself that the judge was given false and misleading information in that regard, and that the reduction should not have occurred. Finally, Judge, with respect to the contempt action previously filed, my own email to Mr. John will state that any settlement was subject to my client's approval of certain matters, that it was not final. So I don't know how there can be a claim that that was misleading. And the claim regarding the orthodontia, we will have proof of the receipts sent by Ms. Phillip to Ms. John at the same email, which has worked wonderfully well for 5 or 4 years. Now suddenly he didn't get those receipts. And in fact, they were sent on the very day that the expenses for the orthodontia were incurred. Based on all of that, Your Honor, we're seeking that child support be modified in accordance with the documentation will be provided to provide that Ms. Phillip now maintain the health insurance, Ms. Phillip be granted a parenting time deviation. Ms. Phillip be allowed to include within that the extracurriculars and special educational needs. We're seeking as well for reimbursement based of the amounts wrongly deducted or had to be repaid by Ms. Phillip. And we are seeking that our legal fees, which I doubt we'll get to today, probably be subject to a separate hearing, be awarded to us based on the speciousness of the opposing party's claims. Thank you, Your Honor.
If I may, I'm a little confused about one of your requests, Mr. Tannen. You said repayment of amounts that were wrongly repaid by Ms. Phillip. What are you referring to?
The amounts that were wrongly referred to, the amounts that were over deducted and over reimbursed as a result of the false information provided by your client at the temporary hearing.
Are you asking for this court to modify the temporary order that was entered by the judge and recalculate those figures since the temporary order?
I'm asking this court to reimburse my client the amounts over withheld on that because of the false and misleading information provided to by your client to the court. So yes.
Okay. If I may just have a response to that, Your Honor, I just wanted to make sure I understood the allegations.
Sure.
One, Mr. Tannen wants you to believe that Judge Swall, after hearing evidence at a temporary hearing and their opportunity to present information, that the medical premium that my client provided and the income information was inaccurate, or that any other expenses that Ms. Phillips says needed to be included by the court were not included. And so they're asking you to take Judge Swall's temporary order and go back and say, hey, I'm not hearing that evidence, but what I want you to do is undo res judicata and now give Ms. Phillips back that money since October of 2020. I just want to make sure that's clear, and our position on that, we believe the evidence will show is not true. And also that specific issue is not proper before the court nor alleged in the amended consolidated pretrial order.
It is amended. It is alleged in the amended consolidated order, Your Honor. Moreover, Judge, when a court makes a ruling based on false, and I'm using the term false politely because saying lying at the opening kind of turns a judge's ears off, then the court has the opportunity to reconsider and recalculate. And basically what we're saying is that the ruling was based on lies provided by the other side, and the evidence will establish that. Moreover, Your Honor, even if the court decides not to do that, it goes straight to the opposing party's credibility, which is really one of the fundamental issues in this case.
Okay. Let's just, all right, let's go to our first witness.
Okay, I'd like to call, if we are starting
Judge,
again,
I'm sorry, Ms.
with,
Rubel, will you please let Judge, can you please let my associate, Ms. Misty Carlson, in the room? For some reason, she's not being allowed in.
is that happening? There she is, I see connecting. Are we ready, Mr. Tannen?
Are you in, Misty? We're good to go.
Okay.
Your Honor, we previously had Father Matthew testify, and we obtained that transcript and provided it to the court of that testimony. It's my understanding, based on your direction at this point, that all witnesses are to be recalled for additional testimony. Is that accurate?
I mean, I did read it. I've read over it. So would you like to, you have to recall him for anything, or we can. I don't know, Madam Court Reporter, if she got everything, because when I understand on there, I could tell that there was people dropping off and going to different hearings, and Zoom was messing up. So did the parties feel comfortable? Ms. Rupel, do you feel comfortable?
Judge, we were going to call Father Matthew for redirect or rebuttal, or rather rebuttal later on. Father Matthew's leaving the country to relocate, resettle in India in a few days. Consequently, I was hoping to at least have the opportunity to examine him for purposes of rebuttal to the information provided by Ms. also provided on that one day, probably horribly recorded due to nobody's fault, of Ms. Binu Mansi.
So why don't we do this?
I don't desire to recall Father Matthew. I just wanted some direction from the court because I'm trying to understand what type of rebuttal evidence would be presented from the testimony of Binu Mansi when the questions that were presented to Father Matthew, you know,
Right, I've read.
I ensured to ask him everything that I was going to ask the next witness so that I could impeach the credibility, essentially.
I've read the transcript. Yeah, I'm trying to wonder what rebuttal. She had him on cross. You caught him on cross, if I remember.
I just called him as a witness, and then they had the
Yeah,
opportunity to
yeah, you
cross-examine
had
him.
Right, you had him.
And,
Then you asked him questions and she asked him a couple more.
right, and then Binu Mansi came on making certain claims, or Ann Joseph, and it's sort of the rebuttal to Ms. Joseph that I'm seeking to have Father Matthew now, because there are information conveyed by Ms. Mansi that Father Matthew can rebut because she was making claims about what Father Matthew had done and said.
But my position on that is that if Father Matthew had any testimony about those statements, those questions were specifically asked to him first. And his responses was either, I can't remember specifically, or that never happened. So for him to now go back and now he wants to redo his testimony after another witness and change, I guess, his tune, I'm not sure.
Do my cross and run my case. And then if she objects, she can object.
Well, I understand, Mr. Tannen, but what Ms. Rubel did was called her witness basically to impeach Father Matthew's testimony. So you don't necessarily, if we let witnesses come back and forth and everybody go, you're a liar, you're a liar, then we'd never get finished with the trial. So if there were any further questions that Ms. Rubel has for Father Matthew, then I will let her ask if she had any follow-up questions, because I did read through the transcript and I will admit it as courts one. If you were like, I'll admit it as courts one. But if there was anything else that you needed to ask Ms. Rubel, I will let you.
No, I mean, if Mr. Tan, if you want to stipulate, you said it yourself, and Father Matthew is now being sent back to India after our trial, that would be the only question I have for him is, now after your testimony, are you being kicked out of the church here in the United States?
I mean, because the way it appeared to me, she used the next witness. It appeared to me it was an impeachment witness.
So, Judge, what I would like to ask Father about is the ability in the diocese to conduct secret ceremonies and religious, and the consequences for him. This was first raised on by Ms. Mansi. This was not.
No, it wasn't. That was part of the questions that I asked Father Matthew. He denied that it occurred at all. And so and then the evidence that the exhibit that we specifically tendered was related to the state. I'm just going to repeat what I said before. The witness testified. Mr. Tannen had the complete and unfettered opportunity to cross-examine the witness based on my questions. I presented an impeachment witness. She testified. Mr. Tannen had complete and unfettered access to question that witness, and I would like to try to proceed to our next witness if we can.
Yeah, so it does look like, let me look.
Ms. Rubel basically accused Father of lying and getting kicked out of the country. So we'd like to really have our
no, hold on.
or recross or rebuttal.
Oh, hold on, one at a time. Well, on here you said okay, the court excused Mr. He excused Miss Joseph. And here he did say in here on page, what was this? It's here. So it's line 15, Mr. Tannen, page 46.
What?
Mr. Tannen said, no, Judge, I would like to call Father Matthew for rebuttal and Detective Haft. Ms. Rubel, during your case, I anticipate that Detective Haft to call as my own witness, but I'm still in presentation of my case at this point.
Judge, can you speak up? I'm sorry, ma'am, because you're.
Sorry, I was reading it out loud to
I
myself.
know.
Line 15, page 46, it says, Mr. Tannen says, no, Judge, I would like to recall Father Matthew for rebuttal and/or Detective Haft. So he's either going to stay to the end of the case. Now, what he's going to can rebut isn't you're not going to go back and forth on whether or not what she said was a lie. If there's something in the entire case he can rebut other than going back and forth on whether or not the testimony is a lie.
Mhm.
So if there's an issue in the case, but he's not going to go back and forth on whether or not Miss Joseph is a liar.
Correct.
So if you have something for him to rebut at the end of the case, that's fine, but we're going to move on to the next witness.
Okay, Judge, the only, and I don't mean to be jumping in on this, is Judge Schwal's law clerk understood that Father Matthew was going to be relocated to India and stated, and now at this time it was that, well, when he's there in India, she said we would make every accommodation so that Father Matthew could testify. So what I would ask is at least by the end of the day, because I
Okay.
don't,
Well, this case is going to be over today.
okay,
Because attorney's fees, yeah.
Yeah.
Oh, yeah, it's going to be over today.
at least by the end of the day, I'd like to get him.
Oh,
Well,
yeah, absolutely. So
okay.
if you want to, do you have Father Matthew's phone number?
We do, and in fact, I believe he's in the waiting room. I don't know.
Yes, so I'll be glad to bring him in. I know he takes, I think if he's Catholic, I guess they take a vow of poverty, so he may not have a lot to pack, but what little he does, he's free to go pack. And Father Matthew?
I'm okay with, I can ask my brief question about his relocation, and then if Mr. Tannen wants to question
Oh,
him on, since you just read the transcript,
Okay.
Your Honor, that might be the fastest thing since it's fresh,
Okay.
and you can
All right.
decide what's relevant or not, and then we'll just keep moving.
Okay, we'll go ahead and do that. Father Matthew, do you mind
Yes,
raising your right hand for me?
yes,
Do you swear or affirm the testimony you're about to give in this hearing is the truth, whole truth, nothing but the truth?
I will say only truth.
Okay, I think you did before, but do you mind spelling your name for Madam Court Reporter, please?
My full name is Matthew Ilayadathamadan Worky, but I am called Matthew Worky.
Can you spell the last part? Your full name, I mean, your last name that you just said.
Okay, it is Matthew with one T and Elaydadatham, and Worky is Varkey.
Okay, I think Ms. Rubel has a question or two for you, and then we'll let you
Okay.
go so that you can start packing, and hopefully you'll stay healthy and safe when you go back to India. Go ahead,
Yeah.
Ms. Rubel.
Father Matthew, can you see that chat window? Did I correctly spell your last name in that chat window for the court reporter?
Pardon me?
Do you see the chat window as a chat to everyone? Did I correctly spell your
Chat
last name?
window. Okay, let me open it. Chat window. Everyone, okay. I don't see my name there. Ms. Rubel, I don't see my name there.
You don't see anything in the chat window?
No.
With your name? I'll just proceed. I believe that that's accurate from the last transcript, Madam Court Reporter. Okay. Mr. Varkey, you are now being sent by your Catholic Church here back to India. Is that correct?
Yeah, I'm getting a transfer for my superior to India. Yeah.
And what's your superior's name?
My superior's name, my superior in India is Father Benny,
Who is your superior here that is transferring you to India?
Actually, I belong to missionary order, so there is a contract between the bishop and my superior in India. So my superior has asked me to come back to India for the service in India.
Who is your bishop locally?
Bishop Mark Jacob.
Is that Bishop Mark Jacob at the church that you practice at now?
Pardon me, I didn't hear.
Is the Bishop Mark Jacob at the church that where you reside, practice at now?
Yes. He is in Chicago.
Who is your direct supervisor at the church in Loganville that you currently work at?
Mark Jacob, Mark Jacob, the bishop.
So you have a bishop from Illinois that manages you at your Loganville church?
Yes, because we belong to a Syro-Malabar Catholic Church.
I'm sorry, I didn't understand that. Say that again?
Because we belong to the Catholic Church, there are different the denominations or the different rites. So we belong to the Eastern Rite.
It's a faction of the Roman Catholic Church. Is that
Yes.
accurate?
Yes.
Okay. And you received the transfer information after giving your testimony in this court proceeding. Is that correct?
The discussion was going on for last maybe a year because I was building a church. So
Okay,
I
is that a
was,
yes or a no? Listen to the question first, answer yes or no, and then you can
Yeah.
explain.
Allow the witness to answer.
Okay, sir, you have to answer with a yes or a no, and then you can explain your answer, okay?
okay. So
You-
I got that one, I
Hold on.
think in April.
Father Matthew,
Yes,
you have, no, so you say yes or no, and then you explain.
yes.
Okay.
Okay,
Judge, can we
what can you,
hear the explanation?
Mr.
Can I
Tannen,
explain?
I'd be confused.
yes, you can. Mr. Tannen, Ms. Rubel has this. If not, you can get him to explain. Go ahead.
My
Father.
about my transfer was in discussion with my bishop, my superior for last 1 year. I was building a church here, so my superior and the bishop wanted me to stay till I finished my church. So that church was opened in last August 29th, 2020. Then, as the pandemic and other things took place, everything was going on. I continued for some more time. And the bishop and my superior had decided that I need to come back to India for the further service.
so your testimony is that you started the Loganville Church in August,
No.
August 29th of 2020?
Ma'am, no. This is a church. I was building a new church. The church is already existed here. We were building a new church in the same premise.
There is a Catholic church in
Yes.
Loganville where you have been working, is that correct?
Yes,
But you are now telling me that you started building a new church next to the same church in Loganville in August 29th of 2020.
that was opened, that was blessed or consecrated on August 29th, 2020.
What does that mean?
What does that mean? Means we had a small church. Now we extended to the big church.
Are you talking about building a church building?
Yes,
Okay, so you're telling me that you started building another structure attached to the Loganville church August 20th of 2020.
no, ma'am. I'm saying that building process was there. We blessed or consecrated the church on August 29th, 2020.
So how specifically are you involved in the construction or otherwise consecration of a building?
I am a pastor, so usually the pastor heads that. The parish council does all the other things.
Okay, so just to be clear, your testimony to the court is that you consecrated a new building in August 29th
No.
of 2020. And
Sorry,
let me
sorry.
finish. Let me finish the question, and then you can tell me if you don't understand my question, but the court reporter cannot take us both down talking. This is the problem we had previously. Your testimony was that you were building an additional building next to the Loganville Church where you've been working, and you blessed that building August 29th, 2020. Is that accurate?
No, there is some changes because I cannot consecrate a church. Only a bishop can consecrate a church in the Catholic Church.
Did you not just testify, Father Matthew, that you consecrated a church on August 29th, 2020, and that was the 1-year period that you had discussed with your superiors, concluding and why you were being transferred?
No, ma'am, what I said is that the construction of the church was going on for some time. And it was consecrated by the bishop on August 29, 2020, and opened for the people. Okay. I was part of the construction. So they wanted, since I was part of the construction, my superior wanted me to stay here and complete that construction before I go back to India. So usually I came to work here for the diocese for some time, and I will go back to India to work. That was conditions.
You have been working continuously within the United States in the Catholic Church for at least 8 years. Is that true?
In Atlanta, yeah.
How many total years have you been consecutive here stateside working with the Catholic Church?
14 years.
And during that 14-year time, you have never been sent back to India. Is that correct?
No.
At what point have you been sent back to India during that 14-year period?
Excuse me, I didn't get you what you're asking.
At what time, if any, during the 14-year period that you've been here working in the United States, have you been sent back to India to resume your work duties?
I was not sent back.
Okay, I just wanted to make sure I understood that you had answered no to my question, and I wasn't sure if you were saying that's correct, I have not been sent back, or if you were saying no, I have been sent back.
Okay.
Okay. That's all I have for this witness.
Mr. Tannen?
Thank you. Father, do you know what a burner phone is?
Burner phone is?
Do you know what a burner phone is?
No.
Do you know what a throwaway phone is?
I'm going to object because this isn't rebuttal to the testimony that the witness was asked, or anything additional that would be brought up with this witness.
Judge,
All of any issues or where he's going with this could have been asked when he first testified.
Judge, this is not, this is rebuttal based on Ms. Binu-Monsee's testimony, and I am not arguing as to what Ms. Binu-Monsee said. I am asking Father about his knowledge as to certain telecommunication methods that he knows about or may not know about.
And then objection relevance.
How is that relevant?
Pretty much because opposing party, I'm trying to figure out how the whole testimony Ms. Rubel was eliciting was relevant, but that's another question. I am asking because Ms. Binu-Monsee is ascribing to Father.
Okay,
No.
no, you can't tell. Okay, he doesn't know what those phones are.
Say that again, ma'am.
He
I'm
says
sorry.
he doesn't know. So go ahead. He doesn't know what those phones are. Go ahead.
Okay, thank you, ma'am. Father, being in part of the Catholic Church here in Georgia, do you have to follow the protocols and rules of the local church here?
Yes.
Okay. Does the
Objection,
church-
relevance, and also this information could have been asked from this witness when he originally testified, because he's literally going to try to rebut the testimony of again, the witness that was presented to the court.
same response, Judge. I think I'm allowed to rebut based on the information testified to by Ms. Monsi.
No, Mr. Tannen, I'm really not going to let you sit here and go back and forth. She's a liar. Hey, this was a lie. This was a lie. This was a
No,
lie.
it's not. I'm not saying lies or anything else.
Well, if you're
And-
going to,
I'm sorry, ma'am.
all right, Father, we're going to send you out for 1 second, okay? We're going to bring you right back.
One second, yeah.
What is it that you want to ask him, Mr. Tannen?
Basically, I want to ask him if they have to publish bans, if they have to record marriages in the church records, and if there are penalties in Georgia, if there are secret marriages performed by a priest, and the penalties meaning the Roman Catholic Church. Can he get in trouble if he did that?
Ms. Rubel. I mean, I don't know if he can speak for the Roman Catholic Church. I mean,
Well, the Logan, yeah, you know, would he get in trouble with his superiors here if he did that? Who knows who speaks for the Roman Catholic Church?
I mean, I guess
I will say this.
I guess the answer to all of that would probably be, if it's yes, it would be if somebody found out. But go ahead, Ms. Rubel.
Well, here's my response to that. If the testimony is limited to those issues, then I think that the court has the discretion to weigh the credibility of the witness
Right.
based on additional information of another witness and impeaching testimony. And I rely on the court to do that, but I'm not trying to,
Okay. If you just,
I don't have a problem with that.
you limit it to those 3 questions, Mr. Tannen, we can let him go.
And that's
Okay?
all I put on here.
Okay.
Very good.
All right. Thank you, Father Matthew. You can unmute yourself.
Thank you, Your Honor.
Okay. Father Matthew, in the Loganville church that you're at, do they require a marriage, for a marriage, the publication of bans?
Yes,
And is any marriage in the church or by the church priests or folks recorded in the church records?
the marriage register, if a marriage is done, it will be registered in the marriage record.
What about the church? Is that the church, what would you call it? The actual church has its own register, is that correct?
Yes, yes.
And does the Loganville church, and who's ever in charge of it, prohibit or limit, or let's say prohibit marriages by priests which are not recorded or submitted by a marriage license in Georgia?
If we don't have the marriage license, we don't marry anyone.
And that's in the Loganville church, right?
Yes.
No further questions.
I have a follow-up question. Father Matthew, if you were to perform a marriage ceremony that you did not have a marriage license for, would you, for example, be punished or disciplined by the church, for example, being sent back to India?
No. The thing is that, let me explain a little bit on that. We as a Catholic priest, we are not supposed to bless a marriage without marriage bans published in the church. Also,
Objection, non-responsive. That's not what I asked him. I asked him specifically what would be the ramifications if he were to perform a ceremony without the license. And he's not talking about if he were to do it without a license. He's talking about if he had a license or that type of information.
Father, she just wants to know what would happen if you did it without the license. Period.
I will be suspended from priesthood. I will have a serious objection from the bishop, and they could take disciplinary action against me.
Father Matthew, one follow-up. Did you not have a meeting with your superior, Father Tommy J. Pulajanam Patio, from
And
the
I'm sure you'll-
Loganville Church.
I'm sure you'll send the spelling of that to Madam Court Reporter in the chat.
I'm gonna do it right now. Who is your superior?
Oh, Father Tommy?
Yes, that's my question. Did you not have a meeting with your superior prior to your testimony at all in this court hearing?
Yes, I did, but not in Loganville Church, but in St. Margaret Church.
And you had a meeting with your superior and Mr. John based on the allegations and the statements that have been presented to this court today, that you performed a secret marriage ceremony.
I did have a meeting with Father John and Father Tommy, yeah.
Help me understand. When I was asking you questions about your superior and who that was, why didn't you mention Father Tommy at all?
Wait, let me explain to you a little bit about our congregation and the rules. Father Tommy is not
Objection, non-responsive.
Judge,
Let me,
ask the question.
Your Honor, let me explain what I want
Hold
to.
on, stop. Okay, she wants to know just why didn't you mention his name?
Because officially he is not my original superior, but he is only for a superior who is, he is not a decision-making superior for my life here.
Okay,
Your testimony is that Father Tommy is not a decision-making superior. However, when a congregation member had complaints or concerns about an illegal ceremony that you performed, the first
Objection,
person that
Your
had a meeting with you,
Nothing is in evidence as to this, and it's her witness. There's nothing in evidence as to what she's asking about.
there is his testimony. He just said he had a meeting with Father Tommy and Mr. John.
I did. I'm not denying that.
You would agree that Father Tommy was the person within the church that has superior rank to you that met with you about an alleged allegation or violation of the church policies. Is that accurate?
I would say yes and no, because he does not have decision-making power over me. To transfer me from one place to another place, he does not have the decision-making.
Father Matthew,
Yes,
she's asking if somebody complains, is he the one who addresses the complaints with the other priests?
yeah,
That's all she wants to know, not
Okay.
transfer anything, just who do
Okay.
they, that's it. We have a
Okay.
chief judge, and that's Judge Brasher. So if anybody complains or they think they want to complain about a judge, they all go to Judge Brasher because he's
Yeah.
the one they go to complain. That's what the rest of us don't have to worry about it. They all
Okay.
go to him.
okay.
Did you have any subsequent meetings with Father Tommy after your testimony in this court proceeding or any other superior related to your church?
No,
That's all I have.
Mr. Tannen, can he be released?
I'm sorry, ma'am, please.
Can he be released?
Yeah, I have one question. Father, what was the outcome of your meeting with Father Tommy?
Father Tommy and
I'm going to
John.
object to hearsay.
Pardon me?
Yeah, Father Tommy's not here,
Right.
Mr.
But
Tannen.
what was the outcome? What were the
No, what-
outcome you can testify to? What happened to you, Father, as a result of the meeting?
Nothing
I
happened.
objection hearsay. He can't
Yeah.
testify as to what happened as a result of the meeting because it would come from somebody that's not testifying. That's not a
But
witness.
The outcome of the meeting, he knows what he's doing. If somebody tells me I'm not allowed to do it, I can say, I'm not allowed to do this.
He-
No.
Father Tommy asked me
No,
about
stop.
this.
Stop. No, there's nobody here other than him that we could cross, that anybody could be crossed on. He, not saying that you would, Father Matthew, but he could just make up anything. So you can't cross the other person to see if this conversation or the outcome was actually true. If there's not a document or anything in writing, not that you would,
The opposing party was there, Judge.
what's that?
The opposing party was supposedly at this meeting.
I don't
I
know.
mean, if you want to ask that witness about what occurred at the meeting, but any statements made by anybody by Father Matthew would be hearsay, unless you specifically asked Father Matthew what he said, which permissible. I mean,
Father, has the Catholic Church in your area punished or reprimanded you in any way?
No,
objection, hearsay.
No further questions.
Thank you. Okay, we'll strike that. Father Matthew, let me ask you a question. If you have a couple that's from India, do you do those marriages over here?
no, without a marriage license, we don't.
Do they have marriage license that are issued, and forgive my ignorance, that are issued in India?
No, they need to get a marriage license from the county here.
So if a couple comes from India and their parents are over and they're over here, but they want an official marriage from India, that type of ceremony, but they're just over here and they want to do it over here because maybe family's over here. You don't do those here?
We will do only if they are in the United States, resident of the United States, and have the marriage license from the county.
Okay. All right, so you don't do the ceremonies for the Indian. Okay, thank
No.
you.
Yeah.
Okay,
Am I asking?
absolutely.
I have no further questions, Your
You're
Honor.
excused.
Okay, thank you.
Thank
Thank you,
you.
Father Matthew, for your testimony. I appreciate
Thank
you
you.
accommodating us on more than one occasion.
Do I need to stay or no? Let me know.
No, sir. You stay healthy and safe and have a safe trip.
Thank you. Thank you very much.
Thank you.
Thank you.
Hey, Ms. Rubel.
He's gonna say,
Who's your next
okay,
witness?
I'd like to call my client. And I
Okay.
don't know when the court wants to take a break or not for lunch or how you want to handle that.
You folks let me know. Madam Court Reporter needs to go. Raise your hand. Tell me anything.
Okay, I would like a 4-minute comfort break and then
Sure.
I'm ready to go and get into it. I just didn't want to get into the testimony and then need to take a break, if that's okay.
Okay, that's fine. Go ahead. Madam Court Reporter, you can take a break real quick. No, we're taking a break.